Let's talk about our template for divorce petitions or counter petitions. And it's good to have a checklist when you're drafting or someone else in your office is drafting, and I'll take you through our checklist. We use ProDoc as our starting point, and that's a great document preparation starting point, and there's other, I'm sure they have competitors out there that are also good, but you have to remember that it is a starting point. They don't know, ProDoc doesn't know the facts of your case, so you'll want to modify it to your specific situation, but that is a good starting point. We have a client information form that we use, and we give it to the client to fill out, and that client information form has all the basic data: their name, address, their driver's license, their social security number, what's the date of marriage, what's the date of separation, what are the kids' names, their dates of birth, all the information you would need to draft. So you'll want to send that to them in advance. It'll help your drafter, and be sure that you're relying upon that and not relying upon the other party's pleading if you're doing a counter petition. Because if your own client misspells their child's name and you copy it, that's one thing. If the other side misspelled it and you just carry their mistake forward, that's another thing. So you'd much rather follow what your client says their child's name spelling is. I did have one case where my client misspelled his own child's name, but usually that's not the case. So if it's a collaborative case, you're going to indicate in the document itself, in the pleading, that it is a collaborative case, and we have special further directions on that in the collaborative section. We have a whole template on collaborative law and pleadings, but you'll want to be aware of that. And you may not know yet if it's collaborative. If you're the first person to plead and you haven't had contact yet with the other side, you may not know that it's a collaborative pleading, but if you do know, because it's counter petition or everybody has agreed, you'd want to indicate that. You need to think about and plead for temporary orders if you need a temporary hearing. So, do you need a temporary hearing? Do you need ex parte temporary relief, an emergency temporary relief? And if so, you need to include that. And this is the big tip on that, and this is the hard thing to remember. You have to repeat the relief for every level of relief you're requesting. And what I mean by levels is, you could have 3 levels essentially. The first level would be emergency with no hearing. So I'm asking this judge, they're not going to have a hearing, they're not going to hear from the other side. It's such an emergency, they're just going to sign an order right then and there when I hand them this pleading. So that's ex parte emergency relief. So that's one layer that I would need to specifically state, what am I asking for at that level? The next level would be, I'm asking for the relief on a temporary basis, so not at final trial, but now on a temporary basis, but after we've had notice to the other side and a hearing. So that's your second level. And then your third level is, at final trial, when this whole case is over, this is the relief I want. You might have instances where you want the same relief at each level. An example would be, let's say that you represent one party, Party A, and Party B is a drunken, dangerous, horrible person. And Party B is endangering the child. And Party B is passing out drunk in public with a 3-year-old. Okay, so Party A is going to be saying, you know what? I want Party B to be supervised with this child until they get their act together and get sober. And I want that at every level. I need it right now on an emergency basis, because otherwise tomorrow they're going to get in the car drunk and drive that 3-year-old. I need it after we have a temporary hearing. I'm still going to want supervised time until Party B gets sober and gets their act together. And I'm going to want it on a final trial until we have evidence that Party B's gotten their act together. So that's an example. I'm going to have to state that 3 times in the pleading, and it seems strange to list it over and over, but you do. You have to explain each level in your pleading that you're requesting and list it 3 times. So be aware of that. You'll want to include a request if you have separate property to confirm separate property. And you're confirming it. That's different than awarding it because it's already theirs. So you're confirming their separate property, and almost everybody has some separate property. I mean, furniture they inherited from their family, jewelry that was a gift, happy whatever, other gifts. It has to be an actual gift. You can't create a gift to yourself. I had somebody argue the other day, my $63,000 Mercedes was a gift because I wrote as I bought my Mercedes, I wrote in the check register, gift to me from my husband. That does not a gift make. But assuming it is a real gift, most people do have some gifts throughout their marriage, and gifts would be separate property. So in almost every case, you would plead to confirm separate property. You don't even have to plead specifically what it is at this level. In the decree you will, but in the initial pleading, all you have to say is, we ask the court to confirm separate property. You don't even have to state what you allege it is, because you might not know yet. You might have to do some tracing and things like that. If you want a disproportionate share of the community estate, you have to ask for it, meaning your client wants more than half, which the court can do, but you have to ask for it. And we've cited a case for you here that gives a laundry list of reasons that the court can consider giving your client, and you should list the reasons that apply. But don't list all of the reasons if they don't apply. So be thoughtful. This is an example of maybe the person drafting just checks every single thing that ProDoc allows on disproportionate, but some of them make no sense to your case. So go back and edit those out. Grounds. So we don't have to have grounds for divorce in Texas. Now we can just say we don't get along and we'd like to get divorced, but you can include grounds. And the common one is insupportability, which is we don't get along and we'd like to get divorced. But you can include other grounds. So you can include cruelty, you can include adultery, and there would be instances where you might want to do that. You'd want to be thoughtful, because that's going to cause obviously some aggravation when they receive that pleading, and you can always replead. So as a practice tip, I would be thoughtful. I don't know how much it gains you to claim adultery and cruelty, and I would only do it if you really know you're going to war. If you hope to avoid war and maybe have a collaborative case, or maybe do it a simple settlement, you might not want to include it, because you can always replead. You can replead up to 7 days before trial. I wouldn't wait that long. I would do it sooner, but you might choose to not include it at the outset if you hope to have some peaceful solution. If you want child support, you have to request it. If you want above guidelines, you have to plead for it. It's unusual to get above guidelines, but there are instances where that would be completely appropriate. A great example is a child that has a special medical need that's expensive. You should certainly plead for it. But you cannot get it if you do not plead for it. So you need to include that in your pleading. Some people like and request a right of first refusal, meaning that before the other parent's going to leave the child with a third-party provider, a babysitter, daycare, whatever, for a certain number of hours, that the parent have a right to, because most people would rather have their child with them. So you can ask that, and you can specify the number of hours that you want to include. Attorney's fees request. Clients really like it if they can get attorney's fees from the other side. It is unusual, unfortunately, and if it's a divorce that we're pleading for, which is our example, they're both free and allowed to use community funds and community credit to pay their attorney's fees, but you still might consider whether or not you want to request it. And you'll want to include the firm name, not just the lawyer's name. So you're not awarding it to one lawyer, you're awarding it to the whole firm. Okay, uninsured medical. So we have a lot on our note here, as you see. You'll want to include how we're going to handle medical and, and how we're going to handle uninsured medical, and if that's going to be reimbursed and all of that. So we have a note here to remind you about that. As we talked about, you can amend your pleading. You can amend your pleading throughout the case, and you'll want to occasionally revisit your pleading and see as your case develops if you need to amend it, but you'll want to title it. So if you do amend it, you'll need to title it as First Amendment or Second Amendment, so the court is aware and that you're dealing with the right pleading, and it would be less confusing. So these are some tips to consider and think about when you are drafting your divorce petition or your counter petition in your case. And with all of our templates, you can add other tips that you think of as you're developing your pleadings.